Did you know that child marriages are still legally challenged in India despite existing laws for decades? It's a shocking reality. But what happens if a child marriage takes place? Can it be invalidated? Or do the participants face legal penalties? Stay with me as I break down the Child Marriage Restraint Act, how it works, recent judgments, and what you can do if your rights are violated. The Child Marriage Restraint Act of 1929, often called the Sarda Act, was India's first attempt to legally prevent child marriages. Although amended several times, this law was the foundation for curbing this harmful practice. In 2006, the Prohibition of Child Marriage Act replaced it to provide stricter penalties and clearer guidelines. Despite legal frameworks, India accounts for one of the highest number of child marriage worldwide. The law aims to protect children from early marriage by setting the minimum age for marriage at 18 years for girls and 21 years for boys. But how effective is this law? Let's explore its key features and its application in real life cases. Here is a summary of the points that we are going to discuss. First, minimum age requirement: 18 years for girls and 21 years for boys. 2. Punishment: up to 2 years of imprisonment or a fine of rupees 1 lakh or both. 3. Child marriage validity: it's not automatically void but can be declared voidable. 4. Prohibition officers appointed to prevent and report child marriages. 5. Recent amendments: new proposals aim to raise the legal age for girls to 21 years. Let's now dive into the details of these points and understand the implications with real-world examples. Under this law, the minimum age is 18 for girls and 21 for boys. But what if someone marries below these ages? That's where the voidable marriage clause comes into play. A child married before reaching the legal age can approach the court to annul the marriage within 2 years of becoming an adult. Anyone involved in promoting or conducting a marriage, including parents, priests, or community leaders, can face up to 2 years of jail and a 1 lakh fine. Ending the marriages as witnesses can be prosecuted. In the case Seema Begum versus State of Karnataka, the court sentenced parents to imprisonment for arranging their minor daughter's marriage, making it clear that the law can be enforced even against family members. A child marriage is not automatically void but voidable at the child's request after they turn 18. However, there are exceptions. If the marriage involves trafficking, abduction, or coercion, it is considered void from the beginning. Justice A.K. Sikri once observed that child marriages disrupt childhood and perpetuate gender inequality. Courts now emphasize stricter enforcement, particularly when exploitation is evident. Under the 2006 law, Child Marriage Prohibition Officers are appointed to monitor communities, report upcoming child marriages, and ensure offenders are penalized. Their protective role is critical but underutilized due to lack of awareness and resources. The Delhi High Court in 2018 criticized the lack of officers in rural areas where most child marriages remain underreported. There are proposals to increase the marriage age for girls to 21 years, matching the boys' legal age, aiming to promote gender equality. If implemented, this would mark a historical shift, further discouraging child marriages and promoting higher education for girls. Here's what you can do if you feel your rights are violated. First, annul the marriage. If someone is forced into child marriage, they can file for annulment within 2 years of becoming an adult. Courts have the authority to declare the marriage voidable. 2. Report the incident. You can approach the nearest child marriage prohibition officer or call child helplines like 1098. Anyone can report a child marriage and even anonymous complaints are accepted. 3. Seek protection orders. Victims of forced child marriages can also apply for protection orders under the Domestic Violence Act of 2005 to ensure safety from family members or the spouse involved. 4. Legal aid and support. Victims and their families can seek free legal assistance through legal service authorities or non-governmental organizations, also known as NGOs, focused on women and child rights. First, the Kerala High Court ruling in 2023. The court recently held that the Prohibition of Child Marriage Act supersedes personal laws in the case of underage marriages. This landmark ruling prevents misuse of religious laws to validate child marriages. 2. Draft bill to raise legal age. A 2024 proposal to raise the minimum age for girls to 21 years is under discussion, indicating stricter measures to eliminate child marriages and empower women through education. Here's a recap of what was discussed. First, legal marriage age 18 for girls, 21 for boys. 2. Punishment 2 years imprisonment or rupees 1 lakh fine. 3. Voidable versus void marriages. Child marriages are voidable unless trafficking or coercion is involved. 4. Prohibition officers, essential in preventing child marriages. 5. Recent developments. Courts are taking stricter action and legal reforms are underway to raise the age to 21 for girls. Child marriages rob children of the freedom and future. But the law is now getting stronger, with courts and activists working together to eradicate this practice. If you or anyone you know is at risk, report it and seek help immediately. Every child deserves the right to education and choice in marriage. If you found this information helpful, please like, share and subscribe to our channel for more legal insights. Help us spread awareness by sharing this video with friends and family. Let's make a change by staying informed. Take care and bye-bye.